they first raised flags that they were receiving alternate electors to the Justice Department?
That I believe would have been well before I was special counsel.
Okay. And when you became special counsel, was that part of your, where did the alternate electors case stand, when you became the special counsel in November of 2022?
So the fake elector scheme was part of what I was investigating, and it ultimately became part of the charges in the case.
Okay. But where did it stand as of November 2022?
Where did it stand? I think the people assigned to that investigation were investigating it. Exactly how many interviews they conducted, things of that nature, I can't recall as I sit here right now.
Before you became the special counsel, there was an effort to get DOJ moving on this, and an individual named Amanda Vaughn, a prosecutor on J.P. Cooney's team, indicated that DOJ would not be pursuing the case. Were you aware of that?
Was this when I was special counsel?
This is before you became special counsel.
I don't recall that.
And so the question ultimately is it seems like the alternate electors matter, it seems like it was subject to a lot of starts and stops. And wanted to know whether, after you became the special counsel in November of 2022, were there any starts and stops, or was that a full speed ahead on that probe?
That was a part of the case that we investigated from the time I started until the indictment. It ended up being one of the most powerful parts of the case. We had electors who were going to be witnesses. I referenced earlier a congressman from Pennsylvania who had said this was an attempt to overthrow the government. We had other electors who said, I was told that this would only be used if we won in litigation. And obviously the record in our case showed that the co-conspirators were trying to use their elector votes despite that fact. And again, this goes to the point I made earlier. These are people who wanted to be electors for Donald Trump. They are not people who were opposed to him. They were not people who are from a different political party or enemies. And so the fact that we had elector witnesses like that, felt either they'd been misled or they felt that this whole effort was an attempt to overthrow the government. I thought that was pretty powerful evidence, and so we moved that part of the investigation forward with the rest of the case.
Did your office coordinate with state officials?
You mean interview state officials?
No, coordinate, several other, state probes cropped up, in Arizona, in Fulton County, Georgia. And I'm wondering how you coordinated those efforts.
I know that we got inquiries from state authorities. I'm aware of that. My recollection is that we did not share any evidence with them. Mm-hmm. And I don't think, my recollection is we did not get any evidence from them. We got it from, mm-hmm. That is my recollection, that it was all or largely from public sources.
Okay. Was there somebody on your team who had responsibility for liaisoning with the Attorney General for the state of Arizona, Chris Mays?
I don't believe so, but also the liaisoning, I don't think that, my recollection is that there was not like an ongoing discussion. What I was thinking of, I know we got a letter, for example, from the Attorney General in New Mexico asking for information from us. I don't have a specific recollection as well as to other states. It may well be that we got other inquiries.
So there was no proactive coordination?
No.
Okay, there was no proactive coordination, regular communications with Chris Mays' office in Arizona?
I don't recall any regular communications, but I'm hesitating just because I don't recall, as I sit here, how many times they might have reached out to us or that sort of thing.
Right. How about with the Fulton County DA's office with Fonnie Willis and Mr. Wade?
Yeah, I've never had contact with either of those people.
Okay, do you know if anyone on the special counsel team, on your team, had contact with them after you were appointed in November of 2022? I
don't believe so. I will just say, though, that one of the things we were investigating was things that happened in Fulton County. Particularly, there was an election worker by the name of Ruby Freeman, her mother, and she was the mother of a woman named Shay Moss. They were people that Rudy Giuliani and Donald Trump targeted with absolutely false claims of election fraud, claims that Rudy Giuliani later admitted he didn't have evidence for, claims that he was held liable in defamation for, caused them to endure all these sort of vile threats. And that whole episode, as well as sort of the claims, the false claims about the vote count in Fulton County, we did look into that and collect evidence. I don't have a recollection, as I sit here, that we interacted with the Fulton County DA's office for that, but if we did, it would be only for that.
Okay, did you try to deconflict their prosecution from what you were working on?
Well, we didn't, I was not interested in sharing information with them, so I did not give them information. I'm not even sure, testing my recollection now, but I don't even think we got a request for information from them.
Did you have coordination as far as scheduling was concerned?
I don't recall anything like that.
Okay. Because their proceedings were going on concurrently with your DC case, with the Florida case. So you don't remember you or anyone on your team having communications with Fulton County to coordinate scheduling?
No, I was aware, obviously, that their case was pending, but I did not coordinate any scheduling with them.
Okay. How about with the Attorney General for the state of Michigan?
Again, it may be that they requested information from us. As I sit here right now, I should say I don't have a really good recollection of this subject matter you're talking about, but I don't recall us giving them information, and I don't recall getting information from them.
Who on your team would have that information?
Well, Thomas Wyndham and Molly Gaston led that case, and along with J.P. Cooney, that would probably be people who might recall these things with more specificity than I am.
Okay. So if somebody has the information, one of those three people should be able to help us?
There may be other people in the office as well. I'm saying them because they were the direct supervisors of the prosecutors on that case, and they may have a better recollection.
Same question with the District Attorney of New York's office. Did your office have any communications with that office, coordination?
No recollection of that.
Did you have any communications regarding scheduling?
Again, I have no recollection of that. I was aware of their case pending, but I don't recall any coordination with them.
Did your office or anyone at DOJ, to your knowledge, try to dissuade the District Attorney of New York from bringing that case?
I do not recall that at all. And that I'll just say I have a better memory. I do not remember anything like that.
Were you enthusiastic that the District Attorney of New York was bringing that case?
No, I didn't take any position about it.
Okay. Because, it was going on at the same time that you were trying to move forward your two cases, correct?
Correct.
And you didn't have a view that the case out of the District Attorney of New York's office was going to be a distraction? Litigating whether there's payments to some performer and how that relates to, the Trump Organization's accounting protocols. I mean, that is very different from the two cases you were pursuing.
Yeah, the two cases are completely different.
And so the question was, do you think that the District Attorney New York's case presented a distraction for what you were trying to accomplish?
A distraction. I don't know that I thought about it that way. I can't recall any discussions along those lines.
I mean, there were a number of times when you wanted to be in court in D.C. and you had this work around the president's schedule because he was in court in Manhattan, correct?
I'm not sure that's right. Maybe that's right. I don't know if there's a record about that. I don't. Was there? If I shouldn't be asking you questions,
Yeah.
but is there? I don't recall.
Yeah, there is.
Okay. So I'm not disputing you then.
I mean, one of the issues is, the president was represented by, he had his team of lawyers. It was pretty small group. They weren't backed by big law, right? So they didn't enjoy a robust, hundreds of, lawyers back at the office to be able to digest some of these things. And so, President Trump's lawyers, were required to be in New York part of the week, and then they had to come to DC, and then they had to go to Florida. And so the question is, did you ever coordinate with the District Attorney of New York to, maybe not be at trial one day so you could have the
Stop imagining. It's time to bring your Ireland dream trip to life. With Kensington, you experience Ireland differently. With expert private guidance.
a counterpoint to that, if Woodward has a bunch of cases before your office and he's, representing a bunch of people, I mean, he may have felt threatened, but he also may have felt that it was in his strategic advantage to just try to forget about it because he doesn't want to make an enemy of Jay Bratt. I mean, isn't that a fair counterpoint?
I don't think so, based on the number of interactions we've had with him, and also the fact that he didn't even bring it up. Someone else brought it up, and when he was, again, I was told when he was confronted with it, he was surprised someone brought it up, made a reference of, I know how to make a complaint if I need to. That was my recollection. And then when he did make the complaint, he didn't just say, I think this should be referred to OPR. He said, and it may be in this letter, that yes, I think that this, let me make sure I get the language correct. Yes. We respectfully suggest that this matter be referred to the department's Office of Professional Responsibility for a thorough investigation, and that any indictment arising from this investigation not lie until such an assessment is reached, knowing, as we do, that an OPR investigation can take many, many months. So that's my take on what happened. And I think our office responded appropriately to this. I don't credit it, but at the same time, we referred it to OPR so they could look into it.
So if it did happen the way Mr. Woodward or Mr. Brand say it did, you would have an issue with that then. Is that fair?
I have no evidence that any of my prosecutors threatened defense attorneys. If prosecutors under my supervision threatened defense attorneys, they wouldn't be working with me any longer.
Okay. Woodward here is talking about essentially a veiled threat that he believes Bratt was mentioning this off the cuff to try to get him to play ball with NAUTA's cooperation. So if that had happened, you certainly wouldn't condone that, would you?
I would not condone anyone threatening a defense attorney, but I also say that if you've practiced law and practiced criminal law, I mean, that's just not something that would work. I mean, that's not something that I've seen an experienced prosecutor do, and to do it in front of several other prosecutors. It just, in addition to, for all the reasons I said I didn't credit it, I also think it just doesn't make a lot of sense. But to your point, if, unlike this situation, a lawyer who worked under me threatened a defense attorney, yes, that would be inappropriate.
During the last hour, turning the page to a different topic, you said that you had not yet considered a sentencing recommendation had President Trump been found guilty in either one of the cases. I mean, do you think that you would have recommended a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate that on that, because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not, or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in the case.
Okay, and what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. I mean, if we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought or looked at or thought about that issue.
Would that analysis have yielded some jail time, or recommendation for some jail time?
Again, I'm not going to speculate on that because, as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
Do we have any members here? Just, we have a couple minutes left in our round, so I was just making sure
Sure.
we didn't, if we had some members here that needed to ask some questions, we'll make sure we factor that in. The individual who worked for Mark Meadows by the name of Cassidy Hutchison was she was a star witness for the January 6th committee proceedings, and she made some real outlandish claims that, for example, one of them was that President Trump tried to take control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with?
The circumstances regarding President Trump getting in the Secret Service vehicle after the Ellipse speech, yes, I am.
Okay. And what did your offices, did you evaluate that claim?
We did.
Okay. And what was your determination?
Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that.
Okay.
And so we went to, we interviewed, I think, the people she talked to, and then we also interviewed, my recollection's correct, officers who were there, and including the officer who was in the car.
Right.
That officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol, but the version of events that he explained was not the same as what Cassidy Hutchinson said she heard from somebody secondhand. That's
Okay.
correct.
On the morning of January 6th, White House officials told President Trump that people at the rally had weapons. This is the President Trump's speech on the ellipse, and that they did not want to go through magnetometers because they didn't want their weapons confiscated. Cassidy Hutchison initially testified that no one informed President Trump before or during the rally that people did not want to pass through the magnetometers because they didn't want their weapons confiscated. During a subsequent interview, she sort of changed her tune a little bit and claimed that Deputy Chief of Staff for Operations Tony Ornato and other officials did inform President Trump that people standing outside the rally area did not want to go through the magnetometers because they did not want their weapons confiscated. Other witnesses contradicted this claim pretty thoroughly. Did your office evaluate that claim?
Yes, and I think I discussed this earlier. We interviewed a number of people, and I think on this particular claim, there were a number of different perspectives about that. I believe it was Ms. Hutchinson, Mr. Ornato, I believe Mr. Meadows we spoke to about this. As I sit here right now, I cannot recall what each of them said. I know each of them were seeing it from a different perspective, and they were with Mr. Trump at slightly different times. So as I sit here now, I can't recall, but I do recall that there were different perspectives on that question, yes.
Did your office consider whether you would call Cassidy Hutchison as a witness at trial?
We didn't make a final determination about any witnesses, but my recollection as I sit here now is that one of the issues, there were two issues really. One, there were so many witnesses that we could have called, and there was a need if we wanted to present a case in a digestible format where there wasn't just weeks and weeks and weeks of testimony, we had to slim it down. And my recollection with Ms. Hutchinson that at least one of the issues was a number of the things that she gave evidence on were secondhand hearsay, were things that she'd heard from other people. And as a result, that testimony may or may not be admissible, and it certainly wouldn't be as powerful as firsthand testimony. So I don't recall if we made a final determination about that, but I remember in my mind that being a consideration that some of the things that she could offer testimony on would be hearsay, and we wanted to condense the case as much as possible for a clear presentation.
Did you reach a determination about whether her testimony was reliable?
I don't recall reaching any sort of conclusion like that because we were, again, far away from trial. We hadn't made final determinations.
If you were a defense attorney and you were given the assignment of cross-examining Ms. Hutchison, would you consider that assignment a very challenging one?
Well, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do is seek to preclude some of her testimony because it was hearsay. And I don't have the full range of her testimony in front of me right now, but I do remember that that was a decent part of it, and so that would have been my first gambit if I was a defense attorney.
There was other evidence where she said she wrote a note, whether it was to Mr. Meadows or Mr. Trump,
Yep.
But it wasn't her handwriting. Eric Hirschman wrote the note.
Yes, there was a conflict between them on that issue. That's correct.
You know, a witness says, I wrote a note, that's my handwriting. I mean, that's a pretty serious, potentially false statement, correct?
Well, like I said, we didn't make any final determinations about who we were going to call or not, but there were instances, you cited a couple where we had evidence, we had different perspectives about an issue, we had secondhand hearsay about an issue, or two witnesses not remembering something the same way. So those are all accurate.
Was your office, let me restate and just say that numerous witnesses that were ensnared by the investigation complained that they were debanked. Does the term debank mean something to you?
No.
Where they were basically told by their bank that they needed to go find a different bank. And there's a long list of, Trump allied, officials that were subpoenaed for the grand jury that were, brought into your investigation that claim they had been debanked. And that Capital One told them to go find a different bank and numerous other banks. Do you know anything about that?
No, I do not.
Okay. So your office didn't have any communications with banks urging a bank to separate from any of their customers?
I have no knowledge of that.
Are you aware of that allegation, or is this the first you're hearing of it?
I'm trying to think. I didn't know what the term meant when you first said it, so, I mean, in the scheme of the world, have I heard of the word debanking? Maybe, but if you'd asked me to define it when you first said it, I don't think I could have.
Okay. But have you, so you haven't heard that allegation that some of the folks in President Trump's inner circle have complained that they, were kicked out of their bank?
Complain to the special counsel's office?
No, they've complained publicly that the fallout from this investigation has made their life very difficult. That they have been, been forced to get a new bank because Capital One won't support them.
I don't recall that, but I'm not denying that people may have said that. I'm not aware of it.
This is sort of the first you're hearing of it?
As far as I can recollect, yes. Well, actually, sir, can I just add one thing there?
Of course.
When you were interacting with my counsel and talking about the issues you might ask about, you said debanking was one of the issues. That was the first I'd ever heard about it.
Oh, okay. All right.
Zaxby's just dropped new lemon pepper. so you can get that zesty lemon and cracked black pepper flavor you love on the chicken you love. Lemon pepper.
The idea of working on any of these investigations. He did bring up the idea of me working on another case before that. So that happened, and I ultimately declined to work on that case, and then the other conversations happened after that. So I just wanted to put that on the record.
Okay.
Murder case not related to.
Not related, correct.
At that point, were you ready to seek a new opportunity? You know, you'd been in The Hague for some time. Were you looking for an opportunity to come back to the United States?
I really loved my work in The Hague, but for family reasons, if the right opportunity happened, I wasn't desperate to come back, but if the right opportunity happened, I was willing to do that. That's one of the reasons I spoke to Mr. Miller.
Okay. At the end of the last round, I asked you whether you had any communications with the Michigan Attorney General, Dan Nessel, and you said you did not.
Yeah, I don't recall any.
And to the best of your knowledge, you don't believe anyone on your staff was having communications with the Michigan Attorney General's office?
Well, what I thought I said was, I don't recall that. It may be that we got inquiries from them. That may be possible, and it may be we responded to those inquiries. I don't recall sharing information with them or getting information from them.
But to the extent there's an allegation made that your office was coordinating with state attorney general's offices to have prosecutions go on, and different prosecutions happen in the states, would you say that did not happen and that would be false if somebody made that allegation?
We were not trying to coordinate prosecutions with other offices, no.
Okay, and you were not trying to encourage prosecutions at the state level?
No, I don't recall anything like that.
Okay. And so the same can be said with the Attorney General for the state of Wisconsin, Josh Call. Did you have any communications with him?
I've never spoken to Josh Call.
Okay.
Again, we may have got inquiries from their office, and it could be by phone or by a letter. I can't say that didn't happen.
Okay. And to the best of your knowledge, your staff did not have a regular set of communications with the Wisconsin Attorney General's office?
I don't know about regular. If there were requests or if there were people who reached out to us, we may have spoken to them back. I don't recall with much specificity anything about that. We definitely were not trying to coordinate a case with them.
Okay. And can the same be said for the Attorney General for Nevada, Aaron Ford?
I don't even know that name, Aaron Ford. Again, I just want to be clear. This subject you're asking me about interactions with State Attorney General's office, this was not a focus of mine. As the special counsel, I was focused on our cases, our investigations, and our case and what we were doing in court in our investigations. This is the sort of thing that other people in my office would have dealt with, and so I'm probably not your best witness in terms of the level of interaction or witnesses, but I don't recall sharing evidence with those offices.
But if your office did have meaningful coordination with the state attorney generals, you probably would know about it. Is that fair?
Meaningful coordination, I don't know what that term means, but like I said, I'm trying to be as specific as I can, limited by my memory. I don't recall us sharing information or sharing our files with attorney general's offices. I don't recall them giving us their files, things of that nature. Beyond that, the number of times an office may have reached out to us and how we replied to that, I really don't have a recollection of those sort of subjects. I'm trying to be as clear as I can.
Fair enough. How about with outside Democratic lawyers such as Norm Eisen? Did you have any communications with Norm Eisen
No.
during the pendency of your investigation? Do you know if anyone on your staff did?
I don't know of anybody having such a communication, no.
Okay. And how about with Mark Elias? He is a election law attorney for Democrats.
No, I've never met him.
Okay. And to the best of your knowledge, your staff wasn't communicating with Mr. Elias?
To the best of my knowledge, yes.
Same question, a gentlelady by the name of Mary McCord.
Mary McCord, I do know. I didn't know her well, but I knew her from when I had brief interactions with her. She was, I think, at the U.S. Attorney's Office in Washington, D.C., while I was the Chief of Public Integrity. I don't recall having any interactions with her during the pendency of the investigations. At the conclusion of the investigations, one of my lawyers went to work at her project at Georgetown, and I did speak to her about that.
Okay, and what is her project at Georgetown?
It's some sort of clinic at Georgetown University. As I sit here right now, I don't know the specifics.
But you didn't have any discussions with her about the facts of the case?
No, my recollection, that may have been the first time her and I had ever actually had a conversation, her and I talking to each other.
Okay.
But we definitely didn't talk about the case while it was being prosecuted and investigated.
We've discussed, both sides, I think, have, raised the fact that President Trump was, he's being prosecuted by a lot of different tribunals at the same time. I mean, he had the District Attorney of New York, he had a civil case with the Attorney General for the state of New York. He had two federal cases. And, I had asked you about how you managed the calendar and the calendar with President Trump. I mean, there were times when he was required to be in New York 3 or 4 days of the week, and then he had to be in Florida for, I think we discussed at the end of our last round, for a pretrial motion hearing. And it just seems that at every instance when President Trump and his lawyers requested a little bit of a delay because of the cases they're defending, your office was not willing to indulge that request.
It is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, and this is in the litigation, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm saying it now, I'm thinking specifically of the executive privilege litigation that we had. This is referenced in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable.
Even against the backdrop that he was being tried by the District Attorney of New York, and even against the backdrop that he was involved in a high stakes proceeding with the New York Attorney General?
Yes.
For example, at the time you proposed the DC schedule, you were also aware that Georgia prosecutors had proposed motions hearings, essentially during the same time period. If President Trump's lawyers had requested a delay for that, would you have indulged that? Or did you indulge that if they did ask for it?
I don't recall if they asked for a delay, and to consider whether I would indulge that, I would have to be back in that moment and look at the facts as they existed at that time. I don't recall that as I sit here now.
President Trump complained that he was treated unfairly with respect to access to the classified information that was at the heart of the Florida case, that he wasn't able to review the materials at the heart of the trial because of restrictions imposed by the government that required him to only review the materials, on your turf. Is that something that your office did intentionally?
I think this may be one of those subjects that may be in the final report in Florida, so I don't think I can get into that.
Okay.
I'm not sure it is, but it may be, and I just want to exercise
Okay.
caution.
So I have some questions along this line. If that's going to be your answer, I understand that. So I'll just,
If you can point to a public filing
Mm-hmm.
where this has been discussed, I'm happy to comment on the subject in the public filing, because I think my understanding is it's pretty clear that I'm allowed to discuss
Mm-hmm.
public filings, and so if there is a public filing you're aware of, I'm happy to
yeah,
address that to the extent I can recall it.
okay.
I want to answer your questions as much as I can, I just don't want to run afoul
Right.
of this injunction.
The heart of the question is, he had a skiff at Mar-a-Lago that was decommissioned when he was no longer president, but during the pendency of the case, it would have been relatively easy for him to get that skiff at Mar-a-Lago back up and running. And, he indicates that your office blocked that and, required him to only look at the classified documents, only talk with his attorneys about the content of the classified documents in a DOJ suit.
So-
And that puts us, a remarkable burden on him, especially given all the other cases that he was defending.
Okay, so if there is a public filing about this, I am happy to discuss this with you. I just want to make sure that there's a public filing, so I'm not running afoul of anything in the injunction.
See if we can get it quickly.
Sure,
If not,
of course.
maybe we'll move on.
Yeah, and then we could come back.
Come back to it. After the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages, and the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of meaty brief? It's almost as if you were writing your, special counsel report in that brief.
Sure. So, as an initial matter, I think the vast amount of the factual material in that brief was not new. It was just put in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be a litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here's the other evidence that we're going to use at trial, in summary at least. We all understood, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we addressed in the final report. Our goal was to have that be one time, and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip as opposed to multiple trips, and multiple trips could mean years in terms of how long it would take to try a case, that required us to go first to, in essence, put this there. And I said this earlier in the day to you, one of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important, that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary. And I think, again, if you look at that brief, the vast majority of factual information in that brief had been in the public or something close to it in the past.
Required you to go first, or you chose to go first? Because the normal case is my understanding, you filed a superseding indictment Defense is gonna make some motion, they're gonna have some reaction to that, and then you would be agreed. But you flipped it.
Well, because in this particular case, we had the opinion that caused us to supersede the indictment. The court said not only what's in the indictment, but the evidence too. And there had never been a point at that point where we had put on the table, here's all the evidence that might be related to immunity. And so we needed to do that. Otherwise, the defense couldn't respond to it. What would have happened would be, we file a brief of our trial evidence, of our indictment. They say no or not. Then that goes all the way up to the Supreme Court. Then we come back from the Supreme Court. Now we're going to do a second year.
Doesn't change the question, Mr. Smith.
I'm sorry.
Was it required, or did you choose it?
I believe that was the most appropriate way to go forward, yes.
It's not my question. Was it required, or did you choose to go that route?
Oh, I chose it.
Okay.
But I'm sorry that I wanted to explain the reasons why I chose it.
And did you have to file a motion with the judge for leave to offer that type of filing?
We had a status conference with the judge shortly after the return of the superseding indictment, and we proposed, my choice, that sequence, but we left it to the judge to decide the timing of that sequence, of when our brief would be due.
And what was the timing of that sequence, to the extent you can recall?
Mr. Smith, who's Marshall Miller?
Marshall Miller was a prosecutor I've worked with.
And well, let me go back to last hour. You said the Democrats, I believe, asked you whether you lobbied for the position. And you said you didn't. But then you followed up and you said you made a call to the Justice Department, someone you knew there. And I think I got the quote right. You said, if there was the right position, I would be interested. What was the right position you were talking about?
If I could take you back, Marshall Miller is the person I was talking about.
Well, that was my next question.
Yeah, I learned that he was returning to the Department of Justice. I was still overseas at this point in my State Department position. I reached out to congratulate him about coming back to the department.
And what position did he have at the department?
He was a senior position in the Deputy Attorney General's office. I'm not sure I'm going to get the exact title right, but it was a senior position in the Deputy Attorney General's
My
office.
understanding, he was Principal Deputy Attorney General, number 3 position.
That could well be.
Okay, so you called him and you told him what?
Well, I initially called him to congratulate him on coming back to the department.
Okay.
And at some point, I told him that if the right position came up, I would be interested in returning to the department.
And what was the right position?
I wasn't specific about it. I just told him if the right thing came up to sort of keep me in mind.
What did you have in mind? Do you want to go back to running the public integrity section?
So
Do you want to be a line lawyer? What do you want to do?
what I recall is right around then, there was a domestic terrorism unit being set up. And I don't know if I shared that with Marshall, but that idea that was being set up, I was interested in things like that, but I didn't have a specific.
When did the call take place?
Well, it wasn't, I'm not going to remember specific conversations. I know shortly after he returned, I reached out to congratulate him on returning to the department. At some point, I don't know if it was then or in a call after that, I said if the right position came up, I would be
And so
interested.
you're saying today, you were no way referencing what many assume might happen, which would be there be a special counsel looking into President Trump. That wasn't on your mind. You weren't anticipating that.
When I told him I'd be interested, no.
Okay. Let's go back to where we left off in our first hour with the toll records. So you seem to indicate that you felt the burden was on the carrier to comply, and that you felt that was consistent with the statute that applies to the United States Senate. Did you feel like you had a burden at all to tell to let the carriers know that we in fact are looking for toll records for numerous United States senators?
I'm sorry, sir, you could, which statute are you talking about?
The statute applies to the Senate, where you referenced that you think the burden is placed on the carriers to deal with this issue with senators, done by the House, but the senators. In our first hour, you said the burden's on them to, if they're going to let the Senate know that their toll records are going to the government, the burden is on them. And I'm just asking, do you feel like there was any burden on the prosecutor, on you, to tell, to make that public?
To make that public?
Not to make it public, to let the carriers know, we are in fact, make it public to the carriers, we are in fact asking for toll records for the United States Senators.
Sir, I don't recall discussing that particular statute. I may have. What I meant to communicate was that reading that statute as it existed at the time, reading it now, it's clear to me that the process that was envisioned.
So you didn't know about the statute back when you requested the tolls?
I do not recall discussing this statute. I can't
Okay.
recall if I knew about it then or not.
Okay, there's definitely a burden based on what the Justice Department is now going to do and move forward. There's definitely a burden now, but you didn't think there was any type of burden for you to let the carriers know these numbers we are giving you are numbers for, excuse me, for United States senators.
As you referenced, the statute has now been changed. And before that change, my understanding is that the statute directed carriers to do this analysis, and in fact envisioned that carriers might get.
So there's no
NDO
burden on you?
applications.
No burden on the prosecutor? That's what I'm getting at.
My reading of that statute as it was drafted at that time is there was not.
Okay. And you ran the public integrity section back in your days at Justice Department, is that right?
Correct.
Did you ever get requests for toll records for this internal analysis that you think was, as Steve said, pretty cursory? Did you ever get requests for members of Congress or United States senators, their toll records?
It was some time ago. I'm sure we may have. As I sit here now, I can't remember a specific instance, but I'm not saying.
How long were you head of the public integrity section?
I was the head from May of 2010 until it was either January or February of I believe 2015.
Okay, 5 years, and in that time frame, you don't know if you got, you can't recall, you may have, I think is, I'm gonna be fair to you, that you don't recall any request for the toll records of members of Congress or the United States Senators.
Well, I'm saying we may well have, and
Okay.
that may well have happened. I just, as I sit here right now, don't recall a specific instance of that. I'm not denying that that happened.
Okay.
Once the department gets the records, what does it do with it? I know that the FBI has something they call the Cellular Analysis Survey Team, CAST. But do you know what happens with the records once they get them?
The analysis, like how they do the analysis.
Like, what do you do with the records?
That would not be in my area of expertise, how the analysis is actually
And
conducted.
how does that get rolled back into the team?
What do you mean?
The team's work, the prosecutor's work? So you subpoenaed Speaker McCarthy's toll records after he became Speaker, and you sought records from November 2020 through January 8th, 2021. Like, what were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened in approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy, and we followed all legal requirements in getting those records.
I mean, you know, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Right, but you could have asked Elliot Burke for that information, the Speaker's lawyer. You could have asked Elliot Burke to say, can you get us the Speaker's, phone records for this time? And he probably would have said, of course, avoiding a toll record subpoena.
And your question?
Why didn't you do that?
We got these records in a manner that was consistent with the law and consistent with department policy. There was nothing improper about how we got these records.
The same with Representative Perry's phone. I mean, you could have asked Representative Perry's lawyer. I mean, there's no evidence that Representative Perry or Speaker McCarthy was interested in obstructing your work, was there?
I don't have any evidence that Speaker McCarthy was, I don't recall any evidence, I should say, that Speaker McCarthy was interested in obstructing our work.
Okay. So with Representative Perry, you could have contacted his lawyer and you could have said, this is what we're looking for. Can you help us achieve this without seizing his phone?
Well, with Congressman Perry, I should point out that the seizure of his phone happened several months before I was ever special counsel. I wasn't
Fair.
involved in that process.
Yeah, okay. But in hindsight, would you have counseled taking a different avenue to acquiring a member's phone?
I'm not going to speculate on investigative steps that occurred before I became special counsel.
Okay. When obtaining the toll records of members of Congress or anyone, what is the standard? Must there be some evidence that relates to a criminal prosecution or criminal investigation?
So there has to be a reasonable basis to believe that there will be materially relevant evidence.
Okay. Now, with the chairman of the Judiciary Committee, the subpoena, with Speaker McCarthy, the subpoena, the timeframe was November 2020 through January 8th, 2021. With the now chairman of the Judiciary Committee, the timeframe went back to January 2020. So it was for a full year where, between January 2020 and December of 2020, nobody, had any telephone calls about these matters. I'm just curious why you went back to January 2020, the office did.
Sorry, I just want to clarify. When you say you went back, can we just get the date of when the
It was
subpoenas
May
were
1st,
issued?
2022, and it was before you were appointed. When I say you, I apologize. I mean the office, the effort. I mean, this was before you became special counsel. The D.C. matters were headed up by Thomas Wyndham, as I understand it,
I believe that's right.
and the Florida matters were headed up by Jay Bratt.
That's
Okay.
correct.
And so the question is, why would DOJ, why would the team seek records from January 2020 through November of that year, before any of these issues, before anyone knew about any of these issues.
Yeah, I played no role in that subpoena. I was still in Europe at the time. And because I wasn't present or involved, I'm not going to speculate on the basis for the range of time that the prosecutors in that case saw it.
Okay. After you became the special counsel, that information obtained from the subpoena, was available to the special counsel team. What did the team do with it after you became, after you were sworn in?
You mean, when you say that information, you're talking about the
The
total?
total record subpoena for the chairman of the committee.
Well, I can tell you that, for example, there was contact on, for example, January 6th, that again, another example for you is Mark Meadows. When we interviewed him, he referenced the fact that afternoon, Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on. And what I recall was Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Right, but DOJ took Mr. Jordan's phone records from January 2020 through November, through January of the subsequent. I mean, what on earth could the Justice Department want with his phone records before time's relevant?
Sure, and the breadth of that subpoena was before I was special counsel, and I wasn't involved in the deliberations about seeking that subpoena or the breadth of it, and so I can't speak to that.
Okay. Can you see from our point of view that there's a perception that there's some overreach going on there?
I understand your question. I don't have any, and I do understand it, I don't have any reason to believe that subpoena was secured for any improper purpose or that it was secured in contravention of department regulations or the law.
Okay. And in terms of
You choose to do this, not required. You go out of the normal order, so that's different. It's 4 times the size of the brief that the court wants you to file, 45 pages, and you do 165 pages. The judge herself said it was